your immigration. Want your immigration.
Hello, 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 hello. Can you help me set the questions so that I can see the questions? Good afternoon, ladies and gentlemen. Welcome to another beautiful Wednesday. This is Dr. Olu Asekun here. Welcome to my weekly podcast. Thank you for joining. Please invite your friends, your colleagues at work, your family members. Invite them to this free podcast. This is where we provide lots and lots of information free of charge. You are at liberty to send in your questions as we go so that I can answer the specific question. Today we are discussing fiancé visa. We are discussing fiancé visa under U.S. immigration law, how a U.S. citizen can bring a fiancé into the United States. That is the topic for today. So as I will be doing preliminary introduction, if you have questions relating to fiancé visa, you can start sending in your questions. Can you please display the number? You can send your questions to 817-883-4495. 817-883-4495. You can also send questions to 817-983-4499. 817-983-4499. You can as well send questions to 817-891-6655. 817-891-6655. So start sending in your questions as we proceed. Now, let me do a preliminary introduction about fiancé visa. Fiancé visa is something that is available to anyone who is a U.S. citizen. If you are a U.S. citizen, you can apply for fiancé visa. You can bring in your fiancé into the United States if you are a U.S. citizen. But of course, there are some specific requirements that must be met, and there are also specific needs. There are specific eligibility requirements for everyone bringing a fiancé into the United States. So I'm going to start with the eligibility requirement for bringing a fiancé into the United States. Did you set it for me to be able to see the questions? Just a minute. Okay, I think I'm fine now. Yes, a U.S. citizen can bring a fiancé into the United States. However, some specific requirement must be met. For anybody to bring a fiancé into the U.S., the petitioner must be a U.S. citizen. In other words, a permanent resident, a green card holder cannot do that. It is only a U.S. citizen that can do that. That is the first requirement. For you to bring a fiancé, you have to be a U.S. citizen. No other person can do it. A permanent resident cannot do it. Anyone on non-immigrant visa cannot do it. H-1B, L-1, any non-immigrant visa, you cannot bring a fiancé. Only a U.S. citizen can do that. That is the first requirement. The second requirement is that the petitioner, the U.S. citizen, and the fiancé, they must have met in person within the last 2 years before the time of application. So you cannot, somebody who is having long range relationship may not be able to bring a fiancé except you have met in person. What? Oh yeah, what? Long distance relationship. Thank you. I'm sure my listener understand what I was trying to say. Okay. Long distance relationship. If you are in a long distance relationship and you have not met in person, you cannot bring a fiancé into the United States. So it's a requirement. You must have met physically in person within the last 2 years, immediately preceding the filing of the application. So even if you met in person, okay, let's say today is October 25. So for you to be able to file a fiancé visa as at today, you must have met the fiancé physically at least October 26, 2021. So if you met in July 2021 and you want to file a fiancé visa today, you will not be eligible. If you have met in 2020 physically, and maybe because of COVID, you are no longer able to travel and all of that, and now you want to file a fiancé visa, it is not going to be approved. You are not eligible. So it's a mandatory requirement. Even though in limited cases, one may apply for a waiver of the 2 years. So fiancé visa is such a visa that is granted for the sole purpose of your fiancé coming into the US to come and get married, so that you two can be married. So if your fiancé entered the United States on a fiancé visa and you do not get married within 90 days, that visa becomes invalid. Your fiancé becomes illegal alien. And of course, your fiancé could be subject to removal. Your fiancé could be deported. So it is mandatory that you get married within 90 days of entry into the United States. So that's another very important requirement that cannot be waived. Now, the point here is that if your fiancé entered the United States and for some reason you break up, you did not get married, your fiancé cannot marry any other U.S. citizen. It is impossible under the current U.S. immigration laws. The only thing your fiancé can do is to go back home. There is no way to adjust. Your fiancé cannot change status. Your fiancé cannot adjust status. Your fiancé cannot, he also has a lot of disadvantages. And one of those major disadvantages is that you cannot marry somebody else. If you come into the US with a visiting visa, if you have a US citizen fiancé and you have a relationship, you can get married and you can adjust your status to that of a legal permanent resident. However, if you come in as a fiancé of a US citizen, you cannot marry somebody else. It is only that US citizen that can petition for you. Nobody else can do it. Even if you get married and you filed, the US citizen refused to file a petition on your behalf, if you eventually get divorced or whether you divorce or not, nobody else can legalize your status in the US. If you enter the US with a fiancé visa, it is a one-chance situation. So the only alternative you have is to go back to your home country. So those are some of the disadvantages of coming in with a fiancé visa. The irony of it is that when people consult with me about whether to bring in their fiancé on a fiancé visa or whether to go back home and get married, depending on who is doing the consultation. So if the US citizen is the one consulting with me, I always encourage them to bring the fiancé with a fiancé visa. That way, the US citizen will have control. The fiancé has no choice. It's a one-chance situation. So it's either the marriage work or it doesn't work. If it doesn't work, you go back home. No, you can't divorce and go and marry somebody else, at least before you become a permanent resident. When you get your green card, that restriction is gone. But until you get your green card, nobody else can petition for you. The only option you have is to go back to your home country. On the other hand, if the person consulting is the fiancé, I always encourage them, have your fiancé come in and get married and let him or her file a petition on your behalf. That way, if things go wrong, you will still be able to get your green card. But if you come in as a fiancé, if things go wrong, the only option is to go back home. There is nothing else. So it depends on who is doing the consultation. So that is why this type of information is very, very important, so that you take decision based on adequate information. So you don't take uninformed decision. Now, fiancé, if the fiancé outside the country, maybe from a previous relationship, you have a child, yes, the child can come in with the same fiancé visa. The principal will get what we call K-1 and the child will get K-2. No separate petition is required to be filed on behalf of the child. The same petition for the fiancé will bring in both of them. However, the same condition that applies to the principal applies to the beneficiary or the derivative, because the derivative, that is the child too, has to come in within 90 days. No, not come in. As far as the principal beneficiary, the mother or the father is concerned, once you enter into the US, the visa is valid for 90 days, and the fiancé must be married to the US citizen within 90 days. If you don't get married within 90 days, you become illegal alien. Now, on the part of the child, the derivative child, because the child is not the one getting married, of course, there is no restriction of 90 days. The child can either come in with the fiancé or come in at a later date, but cannot come later than 1 year. If the child is attempting to come in 1 year after the principal beneficiary has been in the US, then that child will no longer be able to use a fiancé visa. Even if the visa is still valid, it will not be able to use it. It will have to get a new visa in order to be able to come to the United States. Okay, let's start seeing questions before I continue. I think I have some questions here. Is there a way to extend my approved petition? For example, if you cannot get married, you cannot use the same application for the parent. They have to submit their own application, but no separate petition is required from the US citizen petitioner. The next question: is an interview always held when applying for a K-1 fiancé visa? Yes, there is always an interview. You cannot get K-1 visa without an interview. In actual fact, every visa requires an interview except B1, B2, where drop box is allowed. But for fiancé visa, K-1 visa, yes, interview is required. There's no way around that, because one of the requirements for a fiancé visa is to show evidence of relationship. And remember, because the beneficiary, the fiancé, is not in the US, So how is the government going to know that this is a bona fide relationship? The only way to know is by conducting an interview for the applicant. So interview is mandatory when a fiancé visa is filed. They want to be sure that this is a real relationship, because one of the disqualifications for fiancé visa is when the government determines that the marriage is not legitimate, when they determine that the marriage is not bona fide. So it is a mandatory requirement that the marriage be entered into in good faith. The next question. I am recently divorced. Will that interfere with me obtaining a K-1 fiancé visa? No, divorce does not interfere with K-1, because in actual fact, one of the requirements of a fiancé visa is to show that the applicant, that prior relationship must have been terminated either by divorce, death, or annulment. It must have been ended. So you cannot be in a prior relationship and then apply for a fiancé visa. No, it doesn't work like that. So if you have been engaged in any prior relationship, that relationship must be terminated before a fiancé visa can be granted. So having a divorce is not a disqualification. It's actually a requirement. So you have to submit evidence of termination of previous marriage during the interview, and even before the fiancé visa, during the interview, and even before the fiancé visa is approved. The next question. A few years ago, I was removed from the US, but my fiancé, who is a citizen, still resides in the US. Will I be able to gain entry into the US with a K-1 fiancé visa? Well, this question is not detailed enough, because this person did not state the reason why you are removed from the US, because the fact that you have a fiancé does not excuse grounds of inadmissibility. So I have to be able to determine that you are still admissible. You are still admissible to the United States even before you can get a fiancé visa. So this question is not detailed enough, because I don't know the reason for the removal. So if the reason for the removal is based on grounds of inadmissibility, the fact that you have a fiancé will not help that situation. In actual fact, if your grounds of inadmissibility, it depends on the nature of the grounds of your inadmissibility. Fiancé visa may not even be a good idea for you if you are thinking of coming back in, depending on the grounds of inadmissibility. It may be a better idea for your fiancé to come in, you get married, and then your fiancé come back to file a petition. It is something that is waivable. It is something that is waivable. So that will give you that opportunity. But if you just apply for a fiancé visa with a ground of inadmissibility that has not been cleared, then you will not be able to come in. Even if the petition is approved, you will be denied visa at the embassy. And even if you are granted visa, you may still be denied entry at the port of entry. The next question. My fiancé passed away prior to me receiving my K-1 fiancé visa. What is going to happen to the petition? Well, the petition dies a natural death. You can't use the petition anymore, because the purpose of fiancé visa is for you to come into the US and get married to a US citizen. So if the US citizen has passed on, then there is nobody to get married to. So there is no way you can fulfill the terms of the fiancé visa. So the petition dies a natural death. Does the approved fiancé visa mean I can work when I get to the United States? Oh yes, oh yes. Now, let me say this. When you come in with a fiancé visa, there are specific steps that are required to be taken. Number one, when you come into the US with a fiancé visa, you must get married to the US citizen within 90 days. If you don't get married within 90 days, on the 91st day, you become illegal. You become illegal on the 91st day. So it is mandatory you get married within 90 days. Secondly, when you come into the US with a fiancé visa, that visa authorizes you to work at least for the first 90 days. It authorizes you to work for the first 90 days. However, if you comply with the terms, you get married within 90 days, your fiancé can submit a petition on your behalf, and you can apply for green card and then apply for a renewal or an extension of your work authorization. So you can do all of that. But the initial visa authorizes you to work for the first 90 days. So if you get married within that 90 days, then you can file an application for extension of your work authorization for as long as you have submitted an application for adjustment of status, I-485, so you can work. Next question. Is there a way to extend my approved petition? For example, if you cannot get married within the 90 days. No, there's no way to extend it. It's a statutory requirement. The statute requires that you get married within 90 days. It cannot be extended. On the 91st day, you become illegal. There's no room for extension. Next question. What happens if we get married after filing the K-1 visa, but before I migrate? Well, if you get married before the visa is approved, the visa will be denied. And even if the government is not aware, of course, the moment you get married, you are no longer eligible for a fiancé visa. Remember, fiancé visa is meant for you to come to the US to come and get married. So if you are already married, you are no longer eligible. It's as simple as that. The next question. Can I travel to the US for business or pleasure while my K visa is pending? Oh yes, you can do that. You can travel. Fiancé visa is also a non-immigrant visa. So if you have a valid B1, B2 visa, yeah, you can continue to use it while you're waiting for the fiancé visa. The only thing is, if you have a visa, if you have a visiting visa, why will you need fiancé visa? You can as well just come into the US with your visiting visa and then get married. So, because the purpose of fiancé visa is for something is smelling as if something is burning. What? Please. Yeah, I feel as if something is burning. Okay, so if you have a visiting visa, you don't even need fiancé visa, because the purpose of fiancé visa is for you to come to the US to get married. So you can get married while on your visiting visa. So you will not need a fiancé visa for that purpose. The next question. My petition has been pending for a long time. My fiance's country is having a lot of trouble right now in Sudan. Is there a way to expedite? Will it be faster if she applied for asylum? Well, this is a complicated question. You cannot apply for asylum if you are outside the US. So if your fiancé is outside the US, she cannot apply for asylum. Asylum is only available for people who are physically present in the United States. However, your fiancé can apply for refugee status outside the US. He or she can apply for refugee status outside the US. But talking about expedited request, yes, you can submit a request for expedited processing, but it is determined on a case-by-case basis. So there is no guarantee that immigration will grant a request for expedited processing. It is dealt with on a case-by-case basis. But if there is a valid reason why you believe that you are eligible for expedited processing, you can submit the expedited request and then it will be treated on a case-by-case basis. Next question. How soon do I need to travel to the United States once my fiancé visa is approved? You have to travel within 90 days because no, I think it's 120 days. Your fiancé visa upon issue is valid for 120 days. So you have to use it within 120 days. And of course, upon entry into the US, you have only 90 days to get married. So you have to get married within 90 days, otherwise you become an illegal alien. My visa was denied. Can I reapply? Well, I don't think so because fiancé visa is usually approved for a limited period. It is not the kind of visa that will be valid for a long time. So if from the time of approval for a fiancé visa, it is only valid for 120 days, 4 months. Now, that 120 days in limited circumstances may be extended by the Department of State. That is, it can be extended by the embassy or by the National Visa Center. But upon the issuance of a visa, you have to use it within the 120 days, and upon entry into the US, you have to get married within 90 days. The next question. My visa was, I think that's the one I just answered. Okay. The next question. I brought my previous fiancée to the United States on a K-1 visa, but we didn't get married and she returned to our country. I have met someone new. Can I apply for another K-1 visa for my new fiancé? Yes, you can apply. There is no limit to the number of K-1 you can file. The only thing is that the fact that you have brought someone previously with a K-1 visa may create a red flag, and then that may lead to your petition being scrutinized. But at the end of the day, if you pass the scrutiny, you will still be approved because there is no numerical limit to the amount of time a U.S. citizen can file a petition on behalf of a fiancé. So there is no such numerical limit. So it can be done. I mean, no law says that every marriage must work. Things happen. People have misunderstanding. That's why there is divorce court. So if the marriage didn't work and you didn't get married, the good thing about fiancé visa is that the fiancé cannot be legal in the US. So the fiancé will not have a choice than to go back to his or her home country. And because that has happened, the government can no longer use it against you. So there is nothing that can prevent you from filing a K-1 for your new fiancé. The next question. What happens if my U.S. citizen spouse had criminal record? Can the K-1 visa still be approved? Well, it depends. There are some criminal convictions that affect U.S. citizens, and there are some that do not affect U.S. citizens. Generally, any offense under Adam Walsh Act will prevent any U.S. citizen from filing any form of petition on behalf of a family member, whether it's a fiancé petition, whether it's a relative petition, I-130 petition, whether it's a adoption petition, any kind of petition. Anyone who has been convicted of Adam Walsh Act is prevented from bringing in anybody, from filing a petition on behalf of anybody in the United States. Now, you may be wondering what constitutes Adam Walsh offense. Generally, offenses that involve minors, sexual offenses against a minor, those are the general Adam Walsh Act. Maybe child molestation, child pornography, child abuse, child trafficking. Usually, those kind of offenses, it makes it impossible for any U.S. citizen to file any petition on behalf of anybody, not only fiancé, anybody at all, even a wife or a husband. You cannot. The petition will be denied. The next question. Is a medical examination required for the K-1 visa? Oh yes, medical examination is required, but this will have to be taken at the home country of the fiancé. It cannot be taken in the US since the fiancé is not in the US. So upon the approval of the petition, the United States Immigration Services will forward the approved petition to the Department of State National Visa Center. Now, National Visa Center will contact the U.S. Embassy, obtain an appointment, and then forward the petition to the U.S. Embassy in the fiancé's home country. And then the U.S. Embassy, the applicant, the fiancé in this case, will have to conduct medical examination, police clearance, and all other eligibility requirements before attending an interview. Because once the medical examination is conducted, the result will be sent directly to the U.S. Embassy, and then the fiancé will attend an interview. The next question. Why will a K-1 visa be denied? Of course, a K-1 visa can be denied for a variety of reasons. Number one, applicants have to meet the eligibility requirement. I stated this at the beginning of this podcast. Eligibility requirement, the person who is filing must be a U.S. citizen. Two, the fiancé and the petitioner and the U.S. citizen, they must have met in person, physically, at least within the last 2 years immediately preceding the filing of the petition. So they must have met physically. If they have not met, that means the beneficiary is not eligible for fiancé visa. So those requirements must be met. So if someone does not meet the requirement, it can be denied. In addition to those two, the petitioner and the beneficiary, they must show that the relationship is in good faith. The relationship is legitimate. It was not a relationship just for the purpose entered into for the purpose of obtaining immigration benefit. It is not a relationship that is meant only to bring in the fiancé. It has to be a legitimate good faith marriage. So if the embassy determines that the marriage is not in good faith, or if there is any reason for the embassy to be concerned, yes, it can be denied. And because it's an immigrant, because it's a non-immigrant visa, the embassy has the power, they have the authority to either approve or deny. The only thing is, if they are going to deny, they will have to have a reason to deny, but they have the authority to deny. So if the applicant or the petitioner does not meet the requirement. The next question. What type of documentation evidence is needed for a K-1 fiancé visa? Well, when you file a fiancé visa, the first evidence is to show that the petitioner is a U.S. citizen. So you have to show evidence of a U.S. citizenship. If the petitioner was a natural-born citizen, birth certificate will be a good evidence. If the petitioner is a naturalized citizen, copy of the certificate of naturalization will be a good evidence. If the petitioner does not have either of these two, copy of the biometric page of the U.S. passport may be a good evidence. But the petitioner has to provide evidence that he or she is a U.S. citizen. That is the first requirement. The second documentation, I was reading the question to see what the question, documentation or evidence needed. Okay, the second documentation or evidence needed is evidence that the petitioner and the fiancé, they have met physically within the last 2 years immediately preceding the filing of the petition. So the petitioner will have to show his or her American passport, which will show evidence that he or she traveled out of the United States to the fiance's home country. So the passport will show. Remember, we are dealing with the Department of State here. So even if the petition is approved by immigration, irrespective of the home country of the fiancé, so evidence of physical meeting, it also include the copy of the ticket, travel ticket, boarding pass, pictures at the airport, pictures at the home country, but more importantly, copy of ticket, copy of biometric page of passport, boarding pass, another evidence that something that is traceable, that they can see that yes, this person actually traveled to this particular country at this particular time. So you need those things. Then the third kind of evidence that you need in order to get, you have to show how did you meet? How have you been communicating? Do you call each other? If you've been calling each other, you need phone record. Do you text each other? You may have to print the transcript of your text messages. You have to show evidence of relationship. Do you send money to each other? Do you do things that shows that you are actually in a real relationship? So all this will help you to meet the requirement. The next question: does my fiancé have to earn a certain amount of money for us to apply for a K-1 visa? Your fiancé's income is irrelevant here. When we are talking about fiancé visa, your fiancé's income is completely irrelevant. However, for the petitioner have to submit affidavit of support. Remember, this is a non-immigrant visa, so it is not the same affidavit of support for immigrant visa. For immigrant visa, you have to submit Form I-864, affidavit of support. For immigrant visa, the petitioner's income must be 125% of poverty guideline. But in the case of fiancé visa, you have to submit Form I-134, affidavit of support for non-immigrant. And the income does not have to be 125%. The income can be 100% of poverty alleviation guidelines. But in either case, it is the petitioner who will show affidavit of support, not the fiancé. So the fiancé's income is completely irrelevant in this case. The next question: my K-1 fiancé visa is still pending and we have split up recently. Could that affect the decision that will be made? Oh yes, if you have split, it means that you are no longer in a valid relationship. So even if USCIS approve your petition, the fiancé, the beneficiary, will still need to appear at the embassy. And of course, the embassy is still going to ask some questions. So if the embassy finds out that you are no longer together, then it's going to be a problem. But even if the beneficiary was able to scale through and the fiancé visa is given, remember, fiancé visa is only for the purpose of coming into the US to get married. So even if the fiancé gets the visa, he or she will still have to be married within 90 days of entering the US. So if you are no longer together, he or she will no longer be able to get married. And if he or she is not able to get married, then coming to the US will just be a waste of money, time, and energy. Because as I stated earlier, when you come in with a fiancé visa, you cannot adjust your status through any other person other than the petitioner who brought you in. So within 90 days, if you don't get married, she will become illegal alien. She could be deported. Even if she was not deported, she will be illegal. And she cannot marry any other person in the US and get legalized in the US. The only choice is to go back home. So at the end of the day, will it be worth it wasting all of those resources if the relationship is already shaky? The next question: After I get to the US, we get married. I will file for green card. Does my fiancé need to file I-130 petition? Well, the law is actually that I-130 petition and I-485 should be filed. But in some cases where the fiancé visa was approved, the fiancé entered the US, got married within 90 days, and filed application for green card within 90 days, you may not need to submit the I-130 petition along with it. It will still be approved. The next question. Will I get Social Security after I'm admitted with my K-1 visa, or do I need to wait for my employment authorization? Oh, yes. Fiancé visa, upon entry into the US with a fiancé visa, you can use your visa to apply for Social Security number and you'll be given. Remember, fiancé visa allow you to work for the initial 90 days. So if you are able to get married within the 90 days, you can now apply for green card and also apply for employment authorization or an extension of your employment authorization, as the case may be. But of course, any visa that allow you to work will surely allow you to obtain Social Security number. The next question. I came to the US with a K-1 visa. My fiancé and I did not get along well after my arrival. Can I stay in the US? To fiancé visa, it is only the US citizen who brought you into the US on a fiancé visa that can give you green card. Nobody else, not even the president. If you get married or if you come into the US on a fiancé visa based on filed by a US citizen on your behalf, you are stuck to that US citizen. You can only get green card in the US through that US citizen. You cannot get it through nobody else. Even if you marry the American president, you cannot get it. You have to go back home. So it's a one-chance situation. There is no choice. The next question. Does my fiancé need to be present during my interview at the US Embassy? No. Your fiancé does not need to be present. In fact, in most embassies, they will not even allow your fiancé to enter the embassy with you. So even if your fiancé decide to come to your home country, the embassy officials may not allow your fiancé to even enter the embassy along with you. So no, your fiancé, the petitioner, the US citizen, is not required to be physically present at the home country of the fiancé for the visa interview. Go to the embassy for interview. They want to be sure that the petitioner is actually in the US. I've seen situations where the embassy officials, in the course of interview, consular officers requested evidence to see that the petitioner was actually living in the US. Because if you are not living in the US, you cannot bring somebody to the US. If you are bringing somebody to the US, you have to show that you are living in the US. So if you are working outside the US, there's no way you can tell the government that you want to bring a fiancé to the US when you yourself, you are not living in the US. So it's a mandatory requirement that you live in the US before you can tell the government that you want to bring somebody else into the US. So I've seen situations probably maybe through the Department of State. Remember, all US embassies around the world, they are all under the US Department of State. And it is the US Department of State that issues travel documents. So the embassies, through the Department of State, they actually have access to travel information. They know when the beneficiary, when the petitioner, the US petitioner, the US citizen petitioner, when he or she is living in the US and when he or she is not. Because they can see your travel history, They know when you are here. They know when you are not here. And as I stated before, I've seen an example where the consular officer specifically requested that the fiancé, the beneficiary, submit evidence that the petitioner was physically present in the US. And they actually told the petitioner to go to the US Postal Service, to go in front of the post office, take a picture, and send to them so that they can be sure that the US citizen is actually in the US. Yes, yes. I think I answered the last question. Okay. Okay. Okay, the next question I have here, what happens if my US citizen spouse physically abused me before we got married? What? Oh, it's the same question. Okay. Let me read the question again. What happens if my US citizen spouse physically abused me before we got married? I don't know what to do. I came here because of my fiancé. I don't know anyone here in the US, but I have proof of abuse. What options do I have? Well, this is very tricky. From this question, I'm getting the impression that the beneficiary is already in the US. If you are already in the US and you enter the US with a fiancé visa, then you have a choice. If you have documentary evidence of abuse, then you can apply for VAWA. However, if the fiancé is outside the US, you cannot do that, because that simply means that the marriage didn't work and you went back home. So you can't get any benefit for that. But if you are already here and the US citizen has been abusive and you have documentary evidence of the abuse, then you can apply for VAWA. That's the last question I have. Do you still have any other question? Okay, keep the questions coming in. Keep the questions coming in. Keep the questions coming in. We are discussing fiancé today. We are discussing fiancé visa. So it's good to know a lot of things. Information is key. When you don't have information, you take the wrong steps. Okay, I have another question. Do dependent children receiving K-2 visas need to travel to the United States at the same time as the K-1 beneficiary? No, I think I've already answered this at the beginning. No, the dependent children does not necessarily need to travel together. They can travel at a later time. They can either travel together or they can travel at a later time. Once the benefit of the fiancé, they can either come with the fiancé or they can choose to come at a later date, but they cannot come after 1 year. The maximum period upon which they can come on a K-2 visa is 1 year. After 1 year, they cannot come. Now, if the principal beneficiary has obtained green card in less than pregnant, it doesn't stop the fiancé from coming into the US. If the child is born, for as long as the US citizen petitioner is the father of that child, whenever that child is born, the child automatically becomes a US citizen. Whether the child was born outside the US or inside the US, it is immaterial. That child will automatically become a US citizen. But of course, it has to be established that the petitioner, the US citizen petitioner, is the father of that child. The next question. After my fiancé and I marry, what do I have to do to take her out of the country on our honeymoon? How long after we are married can we leave and return to the US? Well, once you get married within 90 days, just go ahead and apply for I-485 and then apply for travel document. So once you apply for travel document, then you'll be able to travel upon approval. If you need expedited processing, request expedited processing of your travel document. Because the thing is, once you file I-485, your fiancé may not be able to travel with the K-1 visa. So K-1 visa was only meant for your fiancé to come to the US and get married to you. It is not meant for your fiancé to be going in and out of the country. In fact, on the visa, the date is stamped on it. It's only valid for 90 days. So once your fiancé entered the US, I-94 is going to show a date, expiration date, which is not going to exceed the 90 days. So it's only valid for 90 days. But if you get married as quickly as possible within the 90 days, then you can submit I-485 and then apply for travel document along with it. So as soon as you get the travel document, you don't necessarily need to wait for the green card. Then you can travel with your fiancé for your honeymoon if you desire to have it outside the US. However, if you did not file I-485, it will not be a good idea to travel out of the country with your fiancé because he or she may not be able to come back to the US. The next question: is the petitioner financially responsible for their fiancé? Oh yes, that's why affidavit of support is required. Yes, the petitioner is financially responsible. That's why they will not give you the fiancé visa until the petitioner has shown evidence that he or she is in a position to take care of the fiancé. That is why they want to see that the petitioner's income is at least within the poverty alleviation guideline for a family, for the family size in question. So if the fiancé does not have any other family member, and if the petitioner too does not have any other family member, then they will look at a family size of 2. But if either of them have additional family member, maybe they have some children or stepchildren or parents, the petitioner has that you don't have a right to disagree, but I tell you, you are probably going to be denied. So you can't eat your cake and have it. If you don't like what they do here, then advice is to stay in your home country. The next question: what's the current processing time for I-129? Well, I don't have the answer to that in my head. Can you please check the processing time for fiancé visa?
Between 5 months and 19 months, depending on the service center.
Okay, we just checked and it's within 5 months to 19 months. So it depends on the service center. So there are multiple service centers that processes fiancé visa. So some of them you get your petition processed within 4 months, and some of them within 8 months, some within 10 months, up to 1.5 years. So it depends on where your petition is assigned to. Oh, is it up to 19 months?
19.
Oh, okay. Within 4 months to 19 months. So that's the accurate information on that. I guess that was the last question. Do you still have a pending question that I've not received here? Well, I guess that's the last question. Any more questions that I've not answered?
Just the filing fee.
And what is that? Please. Okay, someone is asking what is the filing fee for Form I-129. Well, we'll check for you. Huh? Okay, the answer to that is $535. $535. Yeah, of course. That is just for the petition. When you get to the embassy stage, you still have to pay for the visa. This is just to file the petition. Okay, we have come to the end of today's program. Please remember to join us next week, Wednesday. Join us every Wednesday. Invite your friend, invite family. Here is an opportunity to ask any question that you may have, and we will answer the questions. And this is free of charge. We don't charge for this. We do this every week. The only thing you can do to show appreciation is to invite other people so that you get this information to as many people as possible. We are only contributing our own quota to ensuring that people are well guided, because we see a lot of mistakes day in, day out. We see people take steps based on lack of information. And when you go online, there are several information online that are not accurate. So that is why we've decided to do this on a weekly basis. So if you like what we do, the only thing you need to do, invite your family, invite friends, so that other people too will benefit from it. And remember to subscribe to our channel so that whenever we go live, you will be notified. Thank you again for joining us. We'll see you next week. God bless you.
Inocencio, Kimberly Swiglow, Cristal Diaz, no win, no pay. Call us today at telephone number 817-891-6655. 817-891-6655. The Law Office of Olu Asekun, PC. Personal injury claim. No win, no pay. Auto accidents. Insurance claims. Slip and fall. Wrongful death. We can help you. Formidable team. Dr. Olu Asekun, Olatoyosi Asekun, Marisa Ifaragueri, Irene Inocencio, Kimberly Swiglow, Cristal Diaz, no win, no pay. Call us today at telephone number 817-891-6655. 817-891-6655. The Law Office of Olu Asekun.
Una no go pay shishi until we win money for you. Make una call 817-891-6655. 817-891-6655. My people, if una get motor accident wey be say no be you cause am, Law Office of Olu Asekun go fit help una. Una no go pay shishi until we win money for you. Make una call 817-891-6655. 817-891-6655. My people, if
Helping you with your tax return. Are you sure they are doing it correctly? You don't need to file tax amendment. Fair Deal Tax Services can help you. Personal income tax returns, business tax returns. Contact us today. 817-274-1144 extension 602, 817-274-1844 extension 603, 817-891-6655. Of Great Works in Nigeria, Law Resource Center, Scholarships for Indigent Students, Destiny Helper Award, Moot Court Competition, Best Advocacy Student Award, Best Law of Contract Student Award, Best Jurisprudence Student Award, Best Administrative Law Student Award. We are registered in Nigeria and the United States. Support our work. Your donation is tax deductible. To donate in Nigeria, send your donation to Olu and Simi Asekun Foundation, Keystone Bank. Account number 10131-1430. Donate in Nigeria to Olu and Simi Asekun Foundation, Keystone Bank. Account number 10131-1430. To donate in the United States, Zelle your support to Osasekun Foundation gmail.com. Osasekun Foundation agmail.com. The best fulfillment we can have in life is to impact other people's lives. Dr. and Mrs. Olu Asekun. Olu and Simi Asekun Foundation.